Assalamualaikum. Today I will be talking about whether Malaysian Bar are free from political influence, and I will discuss the importance of having an independent bar in Malaysia. My name is Syami Syahran bin Saiful Kahar. My 6 number is BL18051743. Okay. I will start with what is Malaysian Bar by its legal meaning. Okay. The Malaysian Bar is a body corporate created pursuant to Section 41 of the Legal Profession Act 1976, or it is shortly called as the LPA. It has perpetual succession with a common seal, with power subject to the LPA to sue and be sued in its corporate name, and has the power to acquire and dispose properties. The bar plays a lot of roles. It promotes professional improvements of its members and looks after its members' welfare in its image, and provides legal aid to the needy, and stands up against the abuse of power and encroachment into the liberty of the people of the country, as it was enshrined in the Constitution of Malaysia. The Bar Council makes rulings and gives advice on certain questions relating to matters in practice regarding profession and ethics. It is a body to which lawyers can turn during the time of their needs. The objects and powers of the body corporate, which is the Malaysian Bar, are set out in Section 42 of the LPA. It is noteworthy to note that Section 42 1A stated that the Malaysian Bar was introduced to uphold the cause of justice without regards to its own interests or that of its members, and uninfluenced by fear or favour. The functions of the Bar Council and the Malaysian Bar are explained by Saleh Abbas, Lord President, as he was in the case of Malaysian Bar and another against the government of Malaysia, 1987 to MLJ 165. He said, all lawyers upon being admitted to practice as advocates and solicitors automatically become members of the first appellant by virtue of Section 43 of the Act. The management of the affairs of the first appellant is entrusted to a council known as the Bar Council, Section 47 of the Act, consisting of firstly the President, secondly the Vice President, and thirdly the Chairman of each State Bar Committee, and a member elected by such committee. And it was specified, the case was specified in the book titled The Law of Advocates and Solicitors in Singapore and West Malaysia by Tan Yok Lin. It is said that the first statute to control or to give rules regarding the management of advocate and solicitors was the Enactment 22 of 1914. The statute dealt comprehensively with governing the conduct and admission and enrolment of advocates and solicitors. I will proceed. The LPA was originally enacted to read as follows. Section 42 1D stated that the purpose of the Malaysian Bar shall be to advise the government and the courts when necessary in matters affecting legislation and the administration and practice of the law in Malaysia. It was later amended to read as follows. Where requested to do so, to express its views on matters affecting legislation and the administration and practice of law in Malaysia. So, by legislation, the executive has limited the role of the council to examine and report on the current legislation. I will proceed with regards to I will refer to an article that was titled Society, Justice, Transparency and Good Governance for a Just Society Issues and Challenges, which is an article that was delivered at the Catholic Lawyers Seminar in 2000 by Choi Mun-soo. The author stated that the government ought to have requested the Malaysian Bar for its views regarding 12 acts: Internal Security Act, Dangerous Drugs Act, Police Act 1967, Emergency Ordinance, Emergency Act, Essential Security Cases Regulations, Official Circus Act, Sedition Act, Printing Presses and Publications Act, University and Universities College Act 1971, Discipline of Staff Rules for UPM, UKM, UTM and UM made under Section 16C of the UUCA 1971 and the Societies Act 1966. But perhaps the views of the bar were not sought, perhaps for the sake of political expediency and fear of criticism and objections. I will share the contents of an article entitled "The Gradual Erosion of the Powers of the Bar Council in the Malaysian Bar." The author, Yang Pei Kang, lists 7 instances of erosion of the powers of the bar by the executive. The first is the restrictions on the membership of the Bar Council and the State Bar Committee, which is called 7-year rule, restricting the Bar Council and the State Bar Committee members to non-office bearers of any political party. The power to make rules is now subject to the approval of Attorney General. The fourth is the Bar Council is to advise the government upon request only. The fifth is disciplinary committee had been downgraded in position. The sixth is the changes in the composition of the qualifying board. And the last one is the transfer of the disciplinary powers of the to the disciplinary board. I will proceed with a historical example in which the executive and the bar have around themselves some tough times. ESCA, which is Essential Security Cases and Regulation, was introduced in 1975. The bar opposed to those laws as they were perceived to violate law and procedure known to the legal committee. It disregarded all known norms and had total disregard for basic human rights. The witnesses are not subjected to normal evidence law, and the rules of evidence were immaterial. The bar passed a resolution prohibiting members from appearing in such cases. It was a mark of protest. The Malaysian bar was young and strong. The executive then used its powers to limit the powers of the bar. It amended the LPA. It prohibited political office bearers and members of the bar under 7 years of seniority at the bar from holding office in the Bar Council or State Bar Committees. Amendments to the LPA are used by the executive to clip the wings and nip the power and independence of the freedom of the bar. The Malaysian Bar took court action against the government, which it claimed that the amendment breached their constitutional rights. In the case of Malaysian Bar and the Government of Malaysia 1987, the court held that, which is in the case Salim Abbas himself dissented, the proposed amendment which disqualifies lawyers under 7 years and others from being a member of the Bar Committee of the Bar Council does not breach any fundamental rights or the constitutional rights of the bar or its members. The amendment to Section 46 of the LPA includes prohibition of any office bearers of a political party or a state assemblyman or any member of parliament from holding office in the Bar Council and the State Bar Committee. Now, I will talk about what is so important that we have an independent bar in Malaysia. So, as I stated earlier, an independent bar was important to make sure that the rights of each citizen in Malaysia are well cared for in accordance with the Constitution. Without these rights and without these liberties, it's no use to call Malaysia an independent nation. What use is it for if the people of this country are not freed from the tyranny of their own rulers? So, the Malaysian Bar can function as a shield between tyranny and its victims. Thank you.